Hello, my friends. I want to get straight to this. You've been with me on this journey about this case, and I'm so grateful. But I want to remind you this case is about an SA case where a therapist SA'd me, and that was in 2013. Started court in 2015, and I've been in litigations all the way through from the trial court, which ruled against me, the Court of Appeals, first time ruled against me, and on May 21st, 2026, they ruled against me again. And what is interesting for me to share all these videos that I'm going to be posting, because now I'm going to show you exactly what transpired. What it means that when you are going up against attorneys and the court, first note, they are colleagues. I'm not. I'm pro se. That is not favorable, period. I don't care who you are. That is my opinion. Not only is it my opinion, but if you look at the statistics, you will see that that's a fact. That is rare. Courts do not, in my opinion, care for pro se litigants to come into the court. So that's my opinion, and I have a right to my opinion. It's called free speech. And in this instance, in these cases that I've researched and the statistics, it's true. And I hope this video and what I'm telling you all will help someone to keep fighting. Fight the good fight. So let me talk about May 21st, 2026. I received the opinion from the court, and it was a lengthy opinion. I argued numerous arguments in my brief. And as I was in the court, I filed my brief, and the opposing counsel from Ortel and Kelly, they filed their brief. Longmire, the attorney Longmire, filed her reply brief. What is so important to note is that she knew the death of her client, but she never told. We were proceeding on in the court, and he died August the 12th, 2024. We're in the court in 25. She never tells a soul. What does the law say when a person dies and the person knows, or one of the party knows, whether it be the defendant or the plaintiff? You have to file a suggestion of death. Well, let's talk about that. On August the 12th, when he passed away, his counsel said she knew of his death. How do I know that to be true? She told that to the Board of Professional Responsibilities. And we're going to take a note there because the board is a private entity. It has its own fellowship of lawyers. Let me say it that way. That means lawyers are governing themselves. There's one public person, I believe, one or two, but not more. But the bottom line is, how are you supposed to have something fair when your own counsels and your own friends are governing you and saying, okay, if someone files a complaint against you, then you have to go to this Board of Professional Responsibilities, and you believing that you're going to get a fair shake? In my opinion, not so. That doesn't happen. But in this case, let me talk about what did not happen. Mrs. Longmire wrote a letter to the Board of Professional Responsibilities. When she wrote the letter to the Board of Professional Responsibilities, she says, I knew the death of Dr. Ism on August the 12th. And, but she did not say that she informed the court. If she had have informed the court August the 12th, 2024, we were still in litigation. We were still in the Court of Appeals the first time. That would have stopped all the proceedings to allow substitution of the estate to happen. That's what the law says. But it didn't happen. So the board, I filed a complaint with the board subsequently, and I'll get into that. So I'm just trying to go in chronological order so that you can kind of follow me with this. So as we were proceeding on, I didn't find this out until the board had ruled, until the Court of Appeals had ruled against me. When I found out that the Tennessee Appeals Court, forgive me for this, the Appeals Court ruled against me. When the Appeals Court ruled against me, Something in my spirit said something's not right. I tried to go to the Supreme Court. I knew that I had a valid, lawful argument that my case should have been turned over. But again, I'm pro se. So in that, I got a ruling. The Tennessee Supreme Court would not take my case up. A couple of weeks later, then something in my spirit said, check to see what's going on. Come to find out that Dr. Islam had died. He died August the 12th, 2024. I said, wait a minute, hold on. His counsel had to have known, because when he won December the 3rd or December the 4th, 2024, she had to call him and let him know that he had won the case. So start putting this together chronologically. And when I looked at the notice of death on the internet, he died on the 12th, August the 12th, 2024, and he was buried on that same day. Yep. But the court was never informed. I was never informed. It's called a suggestion of death. You have to file it. Not only that, when I had found the information out about his death, his case, or his estate, let me say that much, his estate is the correct word, had already been through probate, had already been filed. And coming out of probate, and I was like, this is amazing. So what did I do? I looked up the law. What does the law say when someone dies? How can the court give an opinion when a person is dead? Can a dead man be ruled upon while we're in court? You thinking what I'm thinking? Why didn't the lawyer not tell the court? She states the reason why she didn't tell the court because the case was final in the trial court and it was a waste of time. The Court of Appeals also agreed with that on May 21st in some sense. Nope, they did agree with that. They also had some other errors. But the law is clear. And I want you all to know that as I go through this, how did a lawyer not tell the court or myself that she knew of the death? Well, when we got back to the trial court, there was a lot of motions that I had to file to get back to the appeals court. The judge was Judge Binkley. We're in the court. I'm arguing these motions for suggestion of death, motion to lift a protective order against Miss Islam. He put a protective order on me for Miss Islam that I cannot contact her by any means. Dr. Islam's late wife. Then there was other motions for Rules 60 to lift, to allow that the judgment that was already entered be void because we had to take on the information that was important. And that information was that he had died. Therefore, if we don't have a suggestion of death, you can't proceed on with the case. That's not true. Well, it is true, but it's according to who's arguing. A pro se litigant finding the law, the exact law, the law that says when someone dies, you have to inform the court. It's not a suggestion, it's a fact. But it's according to who says the fact. And as the opinion came in on May 21st, 2026, it was very interesting. It's the fact that in their opinion that the attorney we give leeway, in my opinion, that she doesn't have to give the information because if it doesn't change the outcome, it's no reason for the suggestion of death. I'm going to tell you in the next video about that opinion.